matter to come before us this morning is State of Ohio versus Terrance Allen. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. Mr. Ludwig, if you would like to reserve any time, if you let me know when you get started, I'll keep track of the clock.
Thank you. I'd like to divide 11 and 4, if I may.
Certainly. We've read the briefs. We're ready to proceed when you are.
May it please the court, my name is Mark Ludwig. I'm privileged to be appointed by this court to represent Mr. Allen. I would be remiss if I didn't say welcome, Judge Kelly. Prior counsel had filed an Anders brief, and this court had said, wait a minute, there may be issues, and there are. I hope by shotgunning 6, I found maybe the one the court saw. But the first thing that needs to be said is that this case does present every parent's nightmare, which is loss of a child. I must first say for the record that our prayers are that the good Lord daily provide comfort to always grieving parents under these circumstances, and that includes those 4-year-old Jamarcus. But it is not empathy or sympathy that compels reversal here. It is clear and plain errors of law which require this court's attention. First, the plea bargain removed the predicate offense from involuntary manslaughter. The mental element of recklessness was gone at the time Mr. Allen entered a guilty plea to involuntary manslaughter. Now, this is not technically a case of 2 inconsistent verdicts, and that's why we filed the supplemental authority of Brown. It's more like an inconsistent response to 1 count. But my learned opponent threw down the United States versus Powell inconsistent verdicts, and I grabbed that sticky glove and started to try to run with it. If it is inconsistent verdicts, we have cited a number of cases along those lines. Collins, Harris, and Atkins in our brief all talk about the inconsistency that results when a predicate offense disappears. And that's what happened in this case. The predicate offense disappeared. Now, what makes this not an inconsistent verdict case is this case didn't go to the jury on 2 counts that they returned an inconsistent verdict. This removal of the predicate offense happens as part of a plea bargain. And that's pretty unusual when this court, and we hope it does, finds that, wait a minute, state, you can't bargain away the predicate offense and then get a guilty plea on the compound offense. You just can't do it. Where those offenses are incorporate an element. When the prosecution is told to do that, that's what wrongfully happened here, it'll stop.
Mr. Ludwig?
Yes.
I have a question for you. Your client pled guilty to the involuntary manslaughter, correct?
He did.
Where in involuntary manslaughter, the offense to which he pled guilty, is the element of recklessness?
It does not, Your Honor.
Isn't the element the fact that he committed a child endangering, and then therefore didn't your client plead guilty to that element?
He did not. The element comes in by incorporated reference of the commission of child endangering.
To which he
remember,
pled guilty?
he did not.
As an element of involuntary manslaughter?
No, he didn't plead guilty to it as an element of the involuntary manslaughter. In point of fact, the plea bargain in this case told him in advance, Mr. Allen, you're going to, the child endangering charge is, quote, going to be removed in its entirety. And all of a sudden, with all due respect, we're trying to get a little bit pregnant here. Wait a minute. If it's removed in its entirety, pursuant to the plea bargain, that has to be enforced. Now, and again, the second assigned error that we've raised is that the plea was involuntary. And this is fairly simple in this sense. Again, Mr. Allen is told that the child endangering count is being dismissed in its entirety. And then during sentence, he is told at the transcripts at page 13, he's told, wait a minute, you're admitting to to child endangering. Well, I think we all have trouble with. You're told it's dismissed in its entirety, and now you're told you're admitting to it. What's Mr. Allen supposed to understand at that point? And that shows that at least the taking of the guilty plea may have had a problem with it.
Of course, first of all, I couldn't find any cases where there was a plea, similar to this case. I don't know if you have any. Might be supplement, but I don't.
No, we don't have a plea case.
Let's just say that they did not dismiss the child endangerment. Wouldn't the court just merge those anyways?
Sure, I think so.
And you'd end up with the same result, correct?
Well, we have a different sentencing hearing.
Yeah.
And when they merge, the convictions may merge for sentencing, but they don't merge as a matter of the commissions of offense. And when they merge, you're merging in the reckless element. It's coming in.
So you think that would have been a more appropriate way for the court to handle it?
Your Honors, I just don't want to spend any time advising the prosecution on how to do things right.
All right, thank you.
And I don't mean that flippantly. I mean,
I don't, Mr. Ludwig, that'd be a first.
it would be. And I probably would be wrong when I do it, so. But the plea remains involuntary for that reason. He's told conflicting things before he pleads. He's not properly sentenced on involuntary manslaughter. First of all, since there's no predicate offense, you can't be sentenced on it. But put that aside for a minute. On our fourth assignment error, what we point out is the trial judge, during sentencing, says and omits that part of the sentencing factor is using the minimum sanctions necessary to protect the language from the statute, from 29-29-12. And this is our merit brief at 21 and in the transcript at page 49. She did not say at sentencing, I have those in mind. What she emphasized were other two. I'm here to punish, and I'm here to make sure, she does not mention the threefold factors. Although she does put in her journal entry, 29-29-12 is followed. Well, again, we're at the point where something is said in the journal entry that really wasn't said at sentencing. Our fifth assignment of error is the involuntary manslaughter and weapon under disability should merge. But, Mr. Allen was sentenced concurrently. Who are we kidding? Yeah, it's probably an assignment of error you can address and you can find merger, but so what? When you do that, this case is going to go back and the prosecution's going to say, well, sentence him to 8 years, and we're right where we started. It may be a wrong, but it's not a wrong that's going to correct the injustice that's happened.
So are you withdrawing it?
No, I'm not withdrawing it. I
just want to make sure that we were on the same page.
bad law in favor of a defendant is better, that doesn't work a result, is better than no law in favor of a defendant, Your Honor. Our final assignment of error was ineffective assistance, and I want to tie this to the entry of the guilty plea. Letting this guy enter a guilty plea when there's no predicate offense anymore is ineffective assistance. In all fairness to my trial counsel, had he said something, I suspect the problem would have been cured right then. But nobody said anything. And it's not like there weren't 3 entities in that room that could have caught this. There's a trial judge that took it after the predicate was gone. There's a prosecution that invited it. And nobody was looking at that. Now, why that would mean, well, you still lose, Mr. Allen, because you didn't raise it, I don't know. But assuming the predicate thing is aside, this case in this record shows that this may have been a bare bones no warrant case. It's in the record. We've cited that. And there was never any motion to suppress file. Now, again, in the context of a guilty plea, how do you make sure that the guy is voluntarily entering his plea unless you at least try to explain to him that there might be grounds for suppression, in which case there's no conviction, there's no evidence for a conviction, and have him say, well, don't do it. Or you say, my chances of doing it are slim.
Geez, wouldn't that be the case in
depends on what the grounds, it depends on what the grounds for suppression are, Your Honor. If, and I want to limit this case to this context, remember, one of the grounds for the guilty plea here is step back a second. Assume that we said to him, Mr. Allen, you have to plead guilty to aggravated loitering. And he enters a plea to aggravated loitering. And there is no such offense. That's what happened here. He entered a plea to involuntary manslaughter without a mental element. Well, you can't do it.
But there was the child endangering in place prior to the plea, before it was dismissed, correct?
Yeah, it was in place when the indictment was returned. It
Up
was,
until the point he pled, it was in place.
no. The deal was, we will dismiss endangering, then you will plead to manslaughter. Don't change the chronology on me, Your Honor.
No, I think we're saying the same thing.
No, we're not. The endangering disappeared before he entered the plea. It was a condition of entering the plea.
Okay. Did the indictment, and I'm sorry, I don't have it in front of me, did the indictment for involuntary manslaughter contain within it, in the commission of a felony,
To wit, child endangering, it did.
In the
And again,
indictment for involuntary
did.
manslaughter?
Yeah, and had the prosecution said, look, we're going to dismiss the child endangering, but the, what was the misdemeanor child offense that was here? There was a misdemeanor child. Had they said that, and said, oh, by the way, that's now the predicate offense for the manslaughter, do you agree? Yeah, but we would have only had a felony of a lower degree, because it's a misdemeanor.
And Mr. Ludwig, you have about 3.5 minutes.
Thank you, Your Honors.
Thank you.
Now, I may please the court, name is Richard Cassay, representing the state of Ohio in this case. I'll start where Mr. Ludwig left off, talking about a motion to suppress. Sounds good, but obviously the Supreme Court of Ohio disagrees with that argument. The gentleman pled guilty, he waived all preceding constitutional errors, if any, that would include a motion to suppress. Beyond that, it's pure speculation that there were grounds to a motion to suppress. So I don't think that argument can go anywhere.
Just out of curiosity, did the court advise him that he was waiting any arguments he would have raised in a motion to suppress?
I don't recall. I don't think trial courts do
I don't
that
think so.
normally.
I don't think-
Perhaps you know some that did, but I don't.
Thanks.
If, before this plea hearing, if he put all these elements on a blackboard and list the elements of them, when the endangering children will erase that because the court dismissed it, nobody's going over to that involuntary manslaughter and erasing child endangering. That is clearly, without a shadow of a doubt, an element of that charge of involuntary manslaughter. And, frankly, I'm surprised I have to come over here and say this. State versus Buhner makes it clear, beyond, again, any shadow of a doubt, that the predicate offense in these compound offenses, such as this one, is an element of that predicate offense. The state has to prove it. If the state did not charge child endangering in a separate count, and this case went to trial, the state has to prove child endangering. Now, what the indictment does not have to have, it does not have to have the elements of child endangering within the count, within the compound offense. That's Buhner. That's settled. So, and I went into the argument about inconsistent verdicts as a penumbra of the law that each count in an indictment is separate. Each count stands as if it were a single indictment. That's what the law is. So, when the defendant bargains for this plea bargain, and trial counsel said, I went over this, every inch of this with him. This is what he wants to do. He did it. And now we're told that 3 entities, I guess that would be the trial court, defense lawyer, and the prosecution, we could have caught this. Well, no. Nobody would catch this. There's no case in the state of Ohio that I'm aware of, and apparently Judge Teodoso could not find, and certainly Mr. Ludwig did not find, that this is some kind of an error. It's a garden variety plea bargain that this defendant wanted and entered into when he signed a plea agreement on top of everything else. Merger, that's an interesting point. Apparently, from what I know of the facts, this child endangering, if there had been a separate conviction and sentence along with the involuntary manslaughter, from what I know, there would have to be a merger because the same conduct that would prove the child endangering in one in the separate would prove it in the compound. So if they merge, there's a conviction, but there's no sentence. That makes it, that would make it, apparently that would make it okay to appellant in this appeal. You have convictions, but you don't have a sentence. Then all of a sudden, you can have a sentence on involuntary manslaughter. You know, really, to state that has got to answer it. That just isn't so.
It would not be,
Pardon me?
it would not be logical that he would want to do that, but it is what would have happened.
Yes,
He would have.
that's what would have happened. But then everything would be okay, according to this defendant in this appeal. Then that would have been fine. 29-29-12. The law is that the court is presumed to follow that statute. It's in the sentencing entry. That's enough. On top of that, the trial court did state, did articulate some considerations that it had before it imposed sentence. He's leaving this gun around where he's had it legally for quite some time, where his child can reach it, and his child picks it up, shoots himself. So that's something the trial court can consider under 29-29-12. Allied offenses. Now, I'm glad that Mr. Ludwig did not withdraw this because in truth, if these were allied offenses, the sentences cannot be imposed concurrently. That's just as bad as imposing them consecutively. I learned that. One thing I learned in the recent State versus Williams case in the Ohio Supreme Court. But there's plenty of evidence here that this gentleman had this weapon illegally well before his child picked it up and killed himself with it. He got his girlfriend or some female friend, Battle, to buy it for him on his gift card because he could not buy it himself. So he had the classic straw man purchase. You buy it for me, and she doesn't want it. She wants him to put it in his name. That's the last thing he's going to do, put it in his name. But the point is that he possessed it well before the child endangering offense took place. So under State versus Smead, I know it's not a self-defense case, but the principle is if the defendant possesses the firearm under disability, which he was, before the offense that is alleged to be allied with, the allied offense argument is no good. So basically, this gentleman bargained for a particular outcome. He received it. He knew exactly what he was doing. And that's it. Simple, I think. I don't know if there's anything, no talk about right to appeal. Obviously, we're here, there's an appeal, and under State versus Fair, that's his remedy. So, don't believe there's any merit to that point either. If there are no further questions, I'll sit down.
Thank you.
The amount of time that it takes me to stand up, I hope doesn't go against me.
I started off with.
Your Honor, please, the court, our brief, page 10, the state negotiated a plea and dismissed the only predicate offense. Citations of authority, State versus Collins. The old days when a minor misdemeanor was used for a manslaughter, traffic manslaughter, and the Supreme Court said, nope, can't use it, therefore there's no conviction for the manslaughter. That's 1993. State versus Harris was an Oregon Supreme Court case where there were two predicate offenses required, only one was shown, and the court said conviction cannot stand. Importantly, State versus Adkins, cited at page 11, the 3rd District found even though it overruled all the assigned errors, it found it was compelled to reverse and remand for plain error because the requisite predicate offenses were incapable of supporting the conviction as a matter of law. And in that case, the predicate offenses went to the jury, they were found guilty of those offenses, and the compound offense. And all the assigned errors are ignored, and the court says, wait a minute, those predicate offenses can't support this. I think it was a RICO case. Can't support it, therefore the conviction's no good.
But weren't the 3 cases you just mentioned, all 3 were jury trials, correct?
They were. And
This is a negotiated plea with a signed plea agreement.
well, I don't remember seeing a signed plea agreement. I'm sure there was. If Mr. Casey says there was, I'm sure there was.
Well, he did, I am.
Oh, if Your Honor says you've seen it, I'll take your word for it.
But again, I got that from the briefs.
Oh, I don't
And
remember
from the
seeing it.
file.
I don't remember seeing it in the file. That doesn't mean prove it exists or doesn't exist. It's a bad memory. In terms of the plea agreement, I understand, and it is the breach of the plea agreement that is a fundamental part of our argument. When you make an agreement to dismiss the predicate offense, quote, in its entirety, close quote, and then the defense accepts, and I'm sorry, I believe the way this goes is there an offer and an acceptance. Not, we did this, we may have gotten there jointly, but the formal approach is the state makes an offer and the defense accepts it, usually. There's nothing in this case that said it was the other way around, and I'm not saying it can't be. Then in terms of the sentencing, the court didn't follow 292912. This is my job as a judge to carry out the felony sentencing guidelines today, and the overriding purpose of the felony guidelines is to punish the offender and protect the public from future crimes. So let's get oriented. We've had rhetoric today, but when we get down to it, that's what I'm concerned about, and we should not forget that. Wait a minute. At sentencing, where are the words, I'm here to punish the offender, quote, using the minimum sanctions that I've determined accomplish those purposes without unnecessarily burdening the state? Well, we didn't say it at sentencing, but we remembered to throw it in the entry, so therefore it's good enough. That's not doing your job at sentencing. That's not doing your job at sentencing, reciting that purpose is in your mind. I learned, I hope I can do this quickly. I learned an interesting word. It's telestai, and it's the ancient Greek. The context that we're all familiar with that it was used was it was said on the cross for the words, "It's finished." But in terms of the actual use of the ancient Greek, it was used in 5 connotations. A servant would say telestai.
And Mr. Ludwig, I would love to hear all 5, but I've given you more time than,
When it was used in the vernacular, a judge would say, "Justice has been served," when this court reverses.
thank you, counsel.
Thank you.
Thank you both for your presentations today. The court will take the matter in advisement, which it will issue a written decision, now to both sides, as well as posted on the Ohio Supreme Court website.